Tips on how to answer law or bar examination questions. The tips I will be presenting here are the collective ideas of bar top-notchers, bar lecturers, and law professors who want to share their experiences and have the desire and concern to help future bar takers. I will try to present these tips in a comprehensive and effective way. So here it is. The then chairperson of the Committee on Bar Examinations, Madam Justice Amerfina Melencio Herrera, submitted a report to the Supreme Court her observations on the 1980 bar exams. Imagine, it was 40 years ago. According to her, several examinees made a very unsatisfactory showing to such an extent that there was one who obtained a grade as low as 7%, while another obtained a grade of 11%. Remember that in order to pass the bar, an examinee must obtain a passing average of 75% with no grade falling below 50% in any bar subject. So here are the 8 bar subjects that an examinee is going to hurdle in a 4-Sunday month-long bar exam. So we have here civil law, which has a weight of 15%, labor law and social legislation 10%, mercantile law 15%, criminal law 10%, political and international law 15%, taxation 10%, remedial law 20%, and last but not the least, legal ethics and practical exercises 5%. To repeat, the passing average is 75% with no grade falling below 50% in any bar subject. Justice Herrera pointed out the general weakness of the bar examinees. She said, and I quote, "The reason for this high mortality rate may be attributed to several factors, but a common denominator is the examinees' inadequate command of the English language." She further emphasized, "The examinees inhabiting the lowermost ranks of the grading scale manifested not just an appalling lack of knowledge of the fundamental legal principles involved in the examination questions, but also an inability to logically string their thoughts together, compounded by an almost incredible deficiency in language skills." Consider the following actual questions and answers of some of the examinees in the 1980 bar, which demonstrate their lack of knowledge of the fundamental legal principles and inadequate command of the English language. Question number 6 of that 1980 bar. An accused was found guilty of double murder and was meted out 2 sentences of reclusion perpetua. How would the accused serve the sentences? One of the bar examinees in that 1980 bar made the following answer: "Both penalties must be served by the accused, and he was electrocuted and died, then it washes out the remaining sentence to serve by the accused." Here you can readily observe that this examinee not only had an appalling lack of knowledge of the fundamental legal principle involved, he also had a poor command of the English language. Now, I want to show you my answer to that bar question. Under the threefold rule, the maximum duration of the convict's sentence shall be determined by multiplying by 3 the duration of the most severe penalty, or by adding all of the penalties imposed, whichever is lower. But the maximum period of imprisonment shall not exceed 40 years. So, in this first paragraph, you can readily observe that I cited the fundamental legal principle involved, which is the threefold rule. Let me continue. In the problem above, the 2 sentences of reclusion perpetua cannot be served simultaneously. For purposes of the threefold rule, reclusion perpetua has a duration of 30 years. 30 years multiplied by 3 is 90 years. On the other hand, 30 years plus 30 years is 60 years. The latter being lower, the same is supposed to be the duration of the convict's sentence. However, pursuant to Article 70 of the Revised Penal Code, the convict shall serve not 60 but only 40 years. So in the second paragraph, you can see the synthesis, meaning to say the application of the law with the facts of the case. And presto, I believe that is the correct answer. Now let's go to question number 11 of that same 1980 bar. Patrolman Cruz, acting under orders of the municipal mayor, who wanted to put a stop to the frequent occurrence of robbery in city of Masukal, patrolled the place. At about midnight, seeing three persons acting suspiciously in front of an uninhabited house and entering the same, he arrested them without warrant and took them to the municipal building where they were detained in jail for about 5 hours before they were released. Patrolman Cruz was accused of arbitrary detention. If you were the judge, would you convict him of the crime charged? Now, a bar examinee in that 1980 bar made the following answer. No, considering his possession as peace officer by the higher authority to patrol the place where robbery are frequent. The one responsible for this is the municipal mayor, who ordered without warrant of arrest, and the act of the patrolman are in good faith, believing to be a robbery entering a house. So the proper party liable is the municipal mayor. You can readily observe from the underscored portions of this answer that this examinee has a very poor command of the English language. No proper use of tenses, no subject-verb agreement. This examinee doesn't even know the difference between the words position and possession. So, how can an examinee like this one pass the bar? And more so, why in the world was he able to graduate? And aside from this inadequate command of the English language, this answer shows the examinee's appalling lack of knowledge of the fundamental legal principle involved. The problem was simply asking whether or not Patrolman Cruz should be held liable for the crime of arbitrary detention. And unfortunately, this examinee couldn't even discuss what arbitrary detention is. So, I am showing this to you not to malign or to make fun of the examinee, this poor examinee who made this poor answer, but to show to you that you should try your best at this early stage of your being a law student to avoid this kind of answer. And how do you avoid this kind of answer? By learning the basics of grammar and at the same time studying well so that you would have an adequate knowledge of the legal provision involved. So you still have time. For purposes of comparison, I'm going to show to you my answer to that bar problem. Here it is. No, Patrolman Cruz is not guilty of arbitrary detention. Article 124 of the Revised Penal Code punishes a public officer who detains a person without legal ground. Under the circumstances, however, Patrolman Cruz was justified in arresting them without warrant since they entered an uninhabited house at midnight and in a place where frequent robberies had taken place. He had a reasonable ground to believe that the three persons were about to commit a crime or a breach of the peace. Hence, their arrest and subsequent detention was with legal ground. Now, I was able to present this kind of answer because I followed the so-called four-paragraph rule, which we will discuss in a little while. Okay? Now, our aim here is not to ridicule and immortalize these mistakes. Our aim is to remedy, correct, and supplement the aforesaid deficiencies so that you will not suffer the same fate. Now, the examiner will be looking and expecting for the following from your answer. Number one, proper understanding and appreciation of the facts, particularly those facts that are material in resolving the given problem. Number two, appreciation of the applicable laws that may come into play. Number three, recognition of the issues posed. Number four, resolution of the issues through the application of the law to the given facts. And number five, presentation and articulation of the answer. Articulation is expressive of the following basic fundamentals: good language, impressive presentation, logical reasoning, and substantial background knowledge of law and procedure. An answer showing the candidate's reasoning faculty is what the examiner wants to read in your examination notebooks. You must also be aware that bar questions are not all case or situational problems. There are other types of bar questions or law questions you ought to know, so you will be able to prepare and answer them properly in case you encounter one. The usual types of bar questions or law examination questions are the case problem type, the enumeration type, the distinction type, the definitions, and the reason behind the law, concept, or principle type. Let us focus on the case problem type. You know why? Because this type comprises an average of 80 to 90% of the questions in every subject. Hence, it is imperative that you are well versed in answering the same. Given that you already know the law, given that you know how to apply it to the set of facts, you are left with one problem. That is, how are you going to present or articulate your answer in the correct manner? A ready outline or structure will tremendously help you to answer faster without missing an important part. By constant practice, you will be amazed at how easy it is to tackle the question and come up with an impressive answer. Let me give you tip number one, the so-called KISS method. It simply means keep it short and simple, or you can also say keep it short, stupid. Examiners do not have the luxury of time to be reading your answers like they would normally do for pleadings or cases. With a very limited time to check thousands of booklets, they would truly appreciate short yet responsive answers. Just think about this. If there are 8,000 bar booklets with an average of 20 questions per bar subject, an examiner only has approximately 1.5 minutes per question for checking. So try your best to give your categorical answer, support it with the law, and apply the law to the facts of the case in the first minute of your answer. Tip number two, the four-paragraph rule. Below is the suggested outline or structure of your answer for a case or a situation or problem type of question. Your first paragraph should have a positive, negative, or a qualified answer. Your second paragraph should contain the applicable law or jurisprudence. Your third paragraph should be a correlation of the law or the jurisprudence with the facts of the case. And your fourth paragraph should contain your conclusion. But this conclusion, you may include it in your third paragraph. So this rule can be called the four-paragraph rule or the three-paragraph rule. No, the four-paragraph rule does not contradict the KISS method. This rule talks about how you are going to make it easier for the examiner to find your answer. It doesn't talk about length. Consider this simple question. X, a Filipino citizen residing in Manila, works as a manager in a multinational company doing business in the Philippines. Previously, he worked as a real estate agent in the US and was able to acquire a house and lot in Michigan, which at present is being leased by a relative of his wife at a sum of 1,000 US dollars a month. Question: is X liable to pay income tax for the income he derived from the lease of his property in the United States? Now, how does the four-paragraph rule work for purposes of answering that question? The first paragraph should say your categorical answer, whether it is a yes or a no, or your qualified answer when the question is vague or general. For example, for purposes of that first paragraph, and in answer to that question, your answer will be yes, X is liable. Your first paragraph could be as short and simple as the above. The second paragraph should contain your legal basis, whether it is an applicable law or jurisprudence. For example, the National Internal Revenue Code provides that a resident citizen is liable to pay income tax for income derived from sources outside the Philippines. So here, what is provided in the second paragraph as legal basis is the applicable law involved. Okay? Your legal basis could be written in a one-liner paragraph like the above. You need not cite the exact chapter or section of the code nor the title of the case or jurisprudence. The third paragraph should be the synthesis. It is where you should apply the law to the given facts of the case. Take note that examiners test not only your knowledge of the law but also your ability to apply the law in various scenarios. For example, here X is a Filipino residing in Manila and earning rental income for his house and lot in the US. The third paragraph is usually the longest among the four paragraphs, as it interlocks the given set of facts with the applicable law. But it can also be a one-sentence paragraph depending on the question at hand. So you can see in the example that there is an interlocking of the given facts with the applicable law. The fourth paragraph is the so-called hence paragraph. It is where you conclude your answer. Usually, it is a repetition of the categorical answer but with a few more details to when it's strong. For example, hence, X as a resident citizen earning rental income in the US is liable for income tax. Your fourth paragraph should conclude and summarize your response to the bar or law exam question. Again, the four-paragraph rule does not equate to the length of the answer. In the examples given above, you will notice that every paragraph is composed of only one sentence each. Thus, your answer should look like this. Yes, X is liable. The National Internal Revenue Code provides that a resident citizen is liable to pay income tax for income derived from sources outside the Philippines. Here, X is a Filipino residing in Manila and earning rental income for his house and lot in the US. Hence, X, as a resident citizen earning rental income in the US, is liable for income tax. By following this rule, the four-paragraph rule, you are helping the examiner check your booklet easier and faster. Since you have a systematic way of answering the questions, the examiner will know where to look for the answers, particularly your legal basis and your synthesis. Tip number 3, logic and common sense. Use logic or common sense when you do not really know the answer. Although some would say common sense is not so common, but I still would like to believe that common sense is common. So you ask the question, what is the best solution or resolution for this case? Or if I were the examiner, how do I want the question answered? Don't just guess. Make a smart guess. Your best guide is to think what is most just and equitable, since these are the purposes any law seeks to achieve. Tip number 4, stick to one. Okay, this rule has nothing to do with your love life. Set those things aside for now. Let's talk about it after the exam. Sana all. The stick to one rule simply means that you should pick a side and take a stand in your answer. A law student should know how to argue based on the provisions of the law and case holdings. Hence, your answer should demonstrate such ability and prove to the examiner that you are worthy to become a member of the profession. Never answer maybe. You should answer categorically. If it is a yes, mean it. Stick to it. Make the examiner believe that your side is the right side. Whether it be in a relationship or in the bar or law exam, abide by the stick to one rule in order to be successful. Tip number 5, to the point. The length of the answer and the expounding of the same must always be proportionate to the points allotted for such particular question. The higher the points, the more in-depth the elaboration should be. However, it must not appear that you are already lecturing the examiner. Sometimes, if your answer is too long, it is an indication that you are not sure of the answer, so there is that need of getting around the bush. Remember that more often than not, the more you talk, the more you commit mistakes. Now, what if the problem is lengthy? If the problem is lengthy, read first what is required at the bottom of the paragraph. By doing this, you will be able to determine what facts are material and what facts are immaterial. You can then start formulating your answer in mind while reading the facts of the problem. Thus, it will be easier and faster for you to write your answers since you are already guided by what is being asked. Here is an example of a lengthy bar problem. This was taken from the 2001 bar. Luis Cruz was deeply hurt when his offer of love was rejected by his girlfriend Marivelia one afternoon when he visited her. When he left her house, he walked as if he was sleepwalking, so much so that a teenage snatcher was able to grab his cell phone and flee without being chased by Luis. At the next LRT station, he boarded one of the coaches bound for Baclaran. While seated, he happened to read a newspaper left on the seat and noticed that the headlines were about the sinking of the super ferry while on its way to Cebu. He went over the list of missing passengers who were presumed dead and came across the name of his grandfather, who had raised him from childhood after he was orphaned. He was shocked and his mind went blank for a few minutes, after which he ran amok and, using his balisong, started stabbing at the passengers who then scampered away, with three of them jumping out of the train and landing on the road below. All the three passengers died later of their injuries at the hospital. Question: Is Louise liable for the death of the three passengers who jumped out of the moving train? State your reasons. Now you can observe that this problem is literally a lengthy problem. So many sentences. So if ever you encounter one in one of your exams or in the bar, go directly to the bottom portion of the paragraph and read the question. After reading the question, then you start reading the problem, and while reading, you can now determine and separate the material from the immaterial statements. Meaning to say, the statements which are not related or insignificant to the question being asked. So here, if you observe closely, the question is Luis liable for the death of the three passengers who jumped out of the moving train? The question calls for whether or not the action of Luis is the proximate cause of the death of the three passengers who jumped out of the train out of fear that Luis, who was carrying a balisong, might harm them. Now, going back to the first three sentences of the problem, it is very clear that, to repeat, these first three sentences have no bearing whatsoever to the question of whether or not Luis should be held liable for the death of the three passengers. Okay? So, that should be that technique whenever you encounter a lengthy problem or legal question such as this one. Here's the suggested answer of the UP Law Center applying the 4-paragraph rule. Yes, under Article 4, Revised Penal Code, any person committing a felony shall incur criminal liability although the wrongful act done be different from that which he intended. In this case, the death of the three passengers was the direct, natural, and logical consequence of Luis's felonious act, which created an immediate sense of danger in the minds of said passengers who tried to avoid or escape from it by jumping out of the train. He is liable for their deaths because he was committing a felony when he started stabbing at the passengers, and such wrongful act was the proximate cause of said passengers jumping out of the train. Let's go to tip number 6. Watch your grammar. Lawyers are expected to have a good command of the English language, both in oral and written communication. Law students and bar candidates, therefore, must work on their grammar and composition. But you should start now. Don't start working on your grammar or improving your grammar when you are already reviewing for the bar. It might be too late already. But if you start now, it is not too late to work on it. With daily practice, you will be able to spot your grammar flaws and correct them just in time for the exams. So those are the 6 tips on how to answer a law examination or bar examination question. But again, this is only a guide material and will not and cannot assure a passing mark. What is assured only is that it will facilitate your presentation of your answers. Okay? Now, I will leave you with this quote, a very good quote which I think is applicable to every law student out there. It says, and I quote, "The brick walls are there for a reason. The brick walls are not there to keep us out. The brick walls are there to give us a chance to show how badly we want something. because the brick walls are there to stop the people who don't want it badly enough. Thank you and good luck in your upcoming exams.